do have skills that make me a nightmare for people like you.
All right, what's the fraud? Let's get down to the issue. What is the fraud? When you take out a mortgage, you create a promissory note. It may not say promissory note on the document, but it's implied, right, the format of the promissory note, against which the banks, quite rightly, create new money by way of credit, and they put it into your bank account so you can buy a home. So that process is quite legitimate. This is the Bill of Exchange Act of 1882. Excuse me. A promissory note defined. A promissory note is an unconditional promise in writing made by one person, you, to another, the bank, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person, the bank. That's what a promissory note is. That's from the Bill of Exchange Act of 1882. So it's recognized legislation. So the point about this is that the banks aren't actually doing anything wrong when they create money out of nothing. And there's nothing wrong with that either. And this is a mistake a lot of people make, because it's there for our benefit. The problem is the benefit has been taken away from us, because what the banks are doing, of course, is they are attaching their own little slice of cake to that, aren't they? And it's not their money. When we sign that form, we are the maker. And if I make something, who owns it? I do. And so what you have to get into your mind is this concept, is that you are getting the benefit of money today, which you will lose the benefit of tomorrow. So you are borrowing from the future, right? So that's a very important concept. Now, when you look at the documentation, there is only one signature on the document, and it's your signature. And what you're actually doing is you're providing evidence to yourself. If you suffer from Alzheimer's in 20 or 30 years' time, you'll say, I don't remember borrowing that money. Somebody can turn around and say, there's your signature. Oh, okay. So it's a very, very important thing to understand that that signature on that document, you are the creator of the money, it's your money. It's your money, and the banks have no right whatsoever to charge you interest. They could rightly charge you a fee for acting as the facilitator. Lord Denning stated in 1969, we have repeatedly said that a bill of exchange or a promissory note is to be treated as cash. It is to be honored unless there is some good reason to the contrary. So when you go into the bank with your promissory note, with your signature, the bank has an obligation to actually give you the money, which they do. And the only good reason that the banks could say, we're not going to do this for you, is if you had an intent not to pay them back, or it was patently obvious that you couldn't pay them back, okay? So there is a very important point. So the actual system is working at the moment up to the point where the banks are doing what they're supposed to do in accordance with legislation, which is give you the money against the promissory note. The scam is the interest. At the same time you get a mortgage, the actual documentation creates what's called a legal deed. Now, this gives them the proprietary right to sell your property if you do not pay your mortgage. So you have two documents in one. One is the promissory note, the other one is a legal deed. And of course, the thing about a promissory note, the most important thing about a promissory note, there is an obligation on you to pay it back. And it is quite correct and proper that there is some security put in place to actually secure that debt. And that's the point about the mortgage deed, or at least the legal deed. But this legal deed has been actually gained by a fraud, because the fraud has been that the banks are trying to persuade you that the bank is lending you its money. It's not. Now, it's a warning here. Negation of the right to sell your property. I argue that the key thing with the bankers at the moment is that we can claim that they've gained that document by fraud, and therefore they do not have the right to claim our property back. But the warning I give is there is still an obligation to pay back the capital. In the same way as an island scenario, we all have responsibilities that we can put as much money into circulation as we want, providing we have a mechanism to bring it back out again. So in, out, etc. So the fraud is that the banks claim they have lent their money. And that's implied. If you look at any document, we are lending you money. Fraud Act of 2006 states quite clearly, a person is guilty of fraud if he is in breach of any of the sections follows, and those sections are fraud by false representation or fraud by failing to disclose information. Did the banks tell us that they were actually facilitating our own money? No, they didn't. It's an outright and unquestionable fraud. So, in my correspondence, I've been writing to quite a few banks on the basis of my knowledge, and it's got quite interesting because they don't tend to reply. But the question, I'm going to explain my sister's case a little bit because that is quite fascinating. My sister got out an interest-only loan about 10 years ago. She's just been paying interest because she couldn't afford to pay interest and capital. She was on Montserrat. Montserrat volcano blew up and she lost everything, so her circumstances weren't very good. She nevertheless got a mortgage interest only, and she was paying off the bank. And it came up for renewal, and the bank said, you've been paying us £650 a month, now I'd like you to pay £2,000 a month. And she said, I can't pay £2,000. And they said, well, we'll foreclose. So she came to see me. And I said, all right, well, I'll write the bank a letter. I wrote the bank a letter with certain information inside it, and they immediately came back and said, yes, we were being too harsh. And she said, bloody hell, she said, I've been doing this for 6 months, and they ignore me. You write one letter, and they immediately back down. So they said, well, you know, we're prepared to accept £1,000 a month. And I said, well, actually, it's not as easy as that, because if you'll see in the letter, you haven't answered the key question. And the key question is about clarity. I've been in touch with the Financial Control Authority and the Ombudsman, and they assure me that if there's anything my sister's not clear about, you have an obligation to explain it. And I would like to explain this to my sister, whether you are claiming you've lent her money or issued or facilitated credit. Which is it? And they won't answer that question. And the question went off to the local bank manager, and he didn't reply. And 6 weeks later, I said, right, ring the bank, get an appointment. So we went in to see the bank manager. Okay? And I said to my sister, you just take note of what goes on. So we sat down and we spoke to the bank manager, and he waffled. He waffled. And my sister told me afterwards his leg was shaking under the table. Yeah. And I just sat there patiently listening to it. And he said, well, we've got to work out how we can repay this within the normal framework of banking. And I said, no, you're going to have to find out how this happens outside the normal framework of banking, because you've lied to my sister. Yeah. And the bottom line, I said, what you've got to do is you've got to take every single penny that my sister has paid the bank in the last 10 years in interest and convert it into capital. You then deduct that from the full capital value and come up with a new value, and then my sister will pay off the balance, the capital balance, over as long as she needs to take. And he said, I'll come back to you on that one. And he resigned from the bank. And then we heard no more. We heard no more. So we're obviously interested. What happened is it was passed to the senior manager, the area manager, who just ignored it. He didn't want to answer the question. And it eventually went back to collections again. So it went down the full circle. And the collections wrote saying, could you tell us what's happening? And we said, well, we're still waiting for an answer from the bank. And the girl was incredulous. Now, the lady involved was a lovely lady, and you know, a nice person who just didn't understand what was going on. And I sort of said, well, I need to know who's going to take responsibility for answering this question. And she said, oh, the area manager will. So I spoke to the area manager, and I said, right, I have been told by this lady that you're going to answer my question. And he said, not me. He said, she'll answer the question. I said, right, are you sure? And of course, what happened then was, I then wrote to the lady saying, he said that you are taking full responsibility for answering the question. That's fine, as long as I know there is somebody taking responsibility. And I would like you to tell me, are you claiming that you have lent my sister money, or are you claiming you facilitated credit? Which is it? because in the past they fudge it, right? They like us to think it's one and the same thing, and it's not. It's fundamentally different. What's the difference? Lending. If you have £500 in your bank account and you lend it to a friend, your account goes from 500 down to 0. His bank account goes from 0 up to 500. So the money is already in circulation and it transfers from one pool to another pool, straightforward. With a facility, credit, the money does not exist to start with. The money is created out of nothing. I think most of us in this room probably understand that. But the point is, what we need to understand is the subtle difference. And we need to hone in on the bank who are deliberately misleading us on this issue, right? They're trying to pretend that they've got the money and they haven't. And as we all know in this room, we are the makers of the money by virtue of the promissory note according to legislation. It's chalk and cheese. Banks do not lend depositors money, right? They create deposits. So when you get a loan, it creates a deposit. Now, we've been saying this for many, many years now, and there's been a general wall of silence from the banks and everyone else. But I tell you what, the work that we've been doing, all around the world, people having to go, we forced the Bank of England to confess. Right, so what does the Bank of England actually say about this?
Ryland, your article was about how money gets
Can you hear that? Can we turn the volume up?
created. We're surrounded here by gold in the vaults of the Bank of England, and historically in the gold standards, the amount of gold would have been related to the stock of money in the economy. Things are very different now. In the modern economy, where does money come from?
Well, let's start off with narrow or central bank money. As the name suggests, central bank money is determined by the Bank of England and consists of notes and reserves. And in normal times at least, notes and reserves are determined by the amount of notes that people want to hold or need for their transactions, and the amount of notes and reserves that banks want to hold, given the level of interest rates in the economy. It is not chosen or fixed by the central bank, as is sometimes described in some economics textbooks.
It's not fixed by the Bank of England.
Your article focuses on broad money. What determines how much of that there is?
Well, broad money, which in many ways is a better measure of the amount of money circulating in the economy, includes all the bank deposits of households and companies. And one of the key points of the article is that banks create additional broad money whenever they make a loan.
Banks create money whenever they make a loan. Okay, so the Bank of England is now coming out and, if you like, confirming what we've been saying for very, very many years, is that the money is created against the loans.
Now, while this is nothing new, it is sometimes overlooked as the main way in which money is created.
The main way in which money is created. And in fact, the main way is 97% of money is created by debt. So the more money we borrow, the more there is in circulation. And I think we can basically understand that. So the simple principle is that we have a debt-based economy because all the money that's in circulation has been created through debts. There is another way of doing that, of course, and it's the way we've done on the island. We created money out of nothing and we gave it to the people. And we had a happy and prosperous island. And the bottom line is that the amount of money you have in circulation is simply determined by how many people that you need and the jobs that you require. It's not difficult to understand. Okay, now I think I'll leave that. I can suggest that if you want to watch those videos, that's on the Bank of England website. If you go to, on the left-hand side, publications, and then that takes you to a page, and then there's the quarterly bulletin, and there are videos. Well worth watching. So it's bankofengland.co.uk. Right, so new money, which is created on the back of a promissory note, belongs to the creator, not the facilitator. The promissory note are to be treated as cash. That is the law, okay? That's Lord Delhi. The bank, therefore, acts as an agent or a facilitator. Have you ever heard the expression, an overdraft facility? They're admitting it in their own documentation. So the point is the bank is not a lender. The bank cannot make money on its own account. That would be deemed as money laundering. Because if the bank could make money on its own account, i.e. without a promissory to pay, they would just do that. They wouldn't need to charge interest. They wouldn't need to lend money. They would just create and buy everything anyway. So the banks can't do it. The banks cannot create the money without our promissory note. It's our money. This is the point I make. The creator of the promissory note can claim without contradiction that they are the legitimate owner of the money. And this is what I've written to the bank. I've written to the bank on behalf of my sister, it's our money. It's my sister's money. She created it, not you. You couldn't make it without her. Okay? And the bank, of course, to date, have not replied. I'm looking forward to the reply. Do you think I'll get an answer? I don't think so. But it's always, and this is the important point, the banks are obliged to create money for you so you can buy a house, just like on the island, subject to one condition, and that condition is we must pay it back. When the bank states that they lend money, when in fact they are facilitating credit, they are actually making a false and deliberately misleading statement. It's not an accident. They know exactly what they're doing. They make a financial gain, and this is part of the Fraud Act, is if somebody makes a false statement from which they make a financial gain, it's fraud. It's unequivocal. This, therefore, justifies a claim for which we are now organizing a class action lawsuit. We want as many people signed up to this class action lawsuit. There are four elements that we're looking at. These are the basic elements, but they certainly spread beyond this. Let's keep it simple for the moment. Question number one, has the bank committed an offence under the law? Yes, they have. They basically not disclosed fully about the actual promissory note issue. Did the banks hide material facts? Yes, they did. They didn't give full disclosure. Has the bank benefited financially? Yes, they have. Is there a victim? Yes, there is. We are the victims. If the PPI scandal was estimated to be worth 40 billion, I can tell you that the claim against the banks for mortgages will be worth many, many trillions, because there's no time bar on fraud, which means we can look at mortgages against the banks for time immemorial. Wow. What a claim that's going to be. But just remember who the banks are working, who the government's working for, the bankers, yeah? So can we expect the government to step in with public interest? Yeah? I mean, we're going to need the banks, otherwise who's going to create the next bubble? And the point I'm making is, of course, that if we took a class action through the normal processes against the banks, the government would step in and they would cry public interest. We can't have the banks being wound up and bankrupt, can we? So we've got to be clever. We've got to box clever. If we accept that the present banking system is the problem, then the solution is an alternative banking system. And that's what we should be working on now. And I have been doing a lot of work in terms of creating an alternative system. I've written a document. I can make the document available to people. I will charge a small fee to keep me on the road. And if people want to contact me, I'll give you my email address. But the point is, we now have potentially an alternative monetary system which we can use, even in a small way. And the very, very simple purpose of that is twofold. Well, firstly, a better monetary system will benefit all of us. But also, secondly, it's the proof that an alternative is available, and therefore they can't claim the public interest issue, can they? We must close that one down. Now, the other important thing is this, that do we believe the judiciary know what's going on? Yes, we do. So we have the banks who are colluding with government and who are colluding with the judiciary. So the bottom line is that any action that we take would have to be via a grand jury. And remember at the very beginning of my presentation, the law of the land that was created by the people, we the people will decide whether the bankers are guilty or not. And when we find them guilty, we will seize their assets. Okay? So that's the job in hand. Preparation. The banks are not going to give up without a fight, are they? So we've got to justify our actions. Is our claim valid? Yes, our claim is valid, and we can prove it. It's irrefutable. The operation. Can we prove that we have an alternative working system? We've got to do that as well. We've got to create a lawful banking system that we can use so that we can actually demonstrate to people that the public interest argument is flawed. It's just a nonsense. And of course, we must also have a constitution. Any banking system that we're looking at must be written for the benefit of all the people. So it's not a commercial enterprise in the sense that it's a group offering a banking service to other people. It's a banking service that's written up with a constitution attached. All right, work in progress. Let me tell you where I am with my sister, which is, it is funny, it's hilarious and all the rest of it, but it's also very, very serious. Of the letters I've written to various banks, I wrote on behalf of somebody to Santander, and they always respond through their solicitors. So we wrote to the solicitors and we said, we believe that your bank is involved in criminal activity and you have a duty of care to make sure that they're not. And the legal firm wrote back about 3 weeks later and they said they'd changed, they were putting our case into the hand of a new company, and it was a limited liability company. So we forced them to go and get some protection. So we are making a difference there. Okay, so in terms of the correspondence from banks, they never answer the questions. They obfuscate, they procrastinate, they do everything. I mean, what was it, 5 weeks from the last letter from my sister. Court appearances are an absolute joke. I've had one judge shout at me, "Did you get the money?" And I said, "You're asking the wrong question. The question is, did we get the money from them?" And we didn't. And they can't prove it. Case dismissed. Didn't happen like that, of course. The judge says, "I am satisfied," which means is another word for "I don't care," right? Found against us. I've had a judge say in the court, "We don't have to pay any attention to the Constitution." I said, "Well, that's you out the door straight away." I said, "There's a Queen's crest behind you. That's where you get your authority from. You've just dismissed your own authority. Bye." And this is what's going on. These people have got... These people have got so arrogant, and they've got arrogant because they're getting away with it, okay? So everything that we're doing now is making them change. Okay, my letter. This is what I'm going to do for my sister next week. I'm quite looking forward to the letter. The point is, this is a very brief and a very, very short version of it, but it's just to give you the gist, okay? Dear bank manager, please find enclosed a promissory note for the value of £100,000, being the capital balance without interest owing on my mortgage. Please use this promissory note to pay off my mortgage, the details of which are attached. Concurrently, please open a new account in my name so that I can pay down the promissory note from future earnings. That's the way it's designed. Please note that this will be done by way of a monthly payment of not £650, but £350 per month until full settlement is made. My sister will be very happy with that arrangement. Please note that the promissory note is in accordance with the Bill of Exchange Act 1882, extant legislation. Please also note that the following appeal court ruling, and that's the quote of Denning's ruling. It would be appreciated if you make best efforts to expedite matters, as I am keen to pay down my mortgage debt as quickly as possible. Thanking you in anticipation. Signed, I've been shafted. I can't wait to get the reply to that letter. I would like everybody who's got a mortgage to write this letter to their banks.
I'm going to do a role play situation of an actual courtroom transcript. Listen carefully to the line of questioning and to the answers. Okay? This is an attorney for a borrower questioning the banker who's on the witness stand who made the loan. All right, so here's how it goes. Let's take a listen. Let's see if the light bulb goes on for you, and then we'll deal with the remedy. All right, here we go. Okay, Mr. Banker, so what is Court Exhibit A?
Well, this is a promissory note.
Is there an agreement between Mr. Smith, the borrower, and the defendant?
Yes.
Do you believe the agreement includes a lender and a borrower?
Yes. I'm the lender and Mr. Smith is the borrower.
What do you believe the agreement is?
We have the borrower sign the note and we give the borrower a check.
Does this agreement show the words borrower, lender, loan, interest, credit, or money within the agreement?
Sure it does.
According to your knowledge, who was to loan what to whom according to the written agreement?
The lender loaned the borrower a $200,000 check. The borrower got the money and the house and has not repaid the money.
Do you believe an ordinary person can use ordinary terms and understand this written agreement?
Yes.
Okay. Do you believe you or your company legally own the promissory note and have the right to enforce payment from the borrower?
Absolutely, we own it and legally have the right to collect the money.
Does the $200,000 note have actual cash value of $200,000? Actual cash value means the promissory note can be sold for $200,000 cash in the ordinary course of business.
Yes.
So, according to your understanding of the alleged agreement, how much actual cash value must the bank loan to the borrower in order for the bank to legally fulfill the agreement and legally own the promissory note?
$200,000.
Okay, so according to your belief, if the borrower signs the promissory note and the bank refuses to loan the borrower $200,000 actual cash value, would the bank or the borrower own the promissory note?
Well, the borrower would own it if the bank did not loan the money. The bank gave the borrower a check, and that is how the borrower financed the purchase of the house.
Okay. Do you believe that the borrower agreed to provide the bank with $200,000 of actual cash value, which was then used to fund the $200,000 bank loan check back to the same borrower, and then agreed to pay the bank back $200,000 plus interest?
No, if the borrower provided the $200,000 to fund the check, there was no money loaned by the bank, so the bank could not charge interest on money it never loaned.
Okay. So if this happened, in your opinion, would the bank legally own the promissory note and be able to force Mr. Smith to pay the bank interest and principal payments?
Oh, I'm not a lawyer, so I cannot answer legal questions.
Well, then, is it bank policy that when a borrower receives a $200,000 bank loan, the bank receives $200,000 actual cash value from the borrower, that this gives value to a $200,000 bank loan check, and this check is returned to the borrower as a bank loan which the borrower must repay?
Well, I do not know the bookkeeping entries.
I'm asking you if this is the policy.
I do not recall.
Okay. Mr. Banker, do you believe the agreement between Mr. Smith and the bank is that Mr. Smith provides the bank with an actual cash value of $200,000, which is used to fund a $200,000 bank loan check back to himself, which he is then required to repay plus interest back to the same bank?
I am not a lawyer.
Did you not say earlier that an ordinary person can use ordinary terms and understand this written agreement?
Yes.
Okay. Okay, Mr. Banker, I'm going to hand you back the bank loan agreement. This is Exhibit B. Is there anything in this agreement showing the borrower had knowledge or showing where the borrower gave the bank authorization or permission for the bank to receive $200,000 actual cash value from him in the note and to use this to fund the $200,000 bank loan check, which obligates him to give the bank back $200,000 plus interest?
No, there is not.
Okay, so if the borrower provided the bank with actual cash value of $200,000 in the note, which the bank used to fund the $200,000 check and returned the check back to the alleged borrower as a bank loan check, in your opinion, did the bank loan $200,000 to the borrower?
In that case, no.
So if a bank customer provides actual cash value of $200,000 to the bank, and the bank returns $200,000 actual cash value back to the same customer, is this a swap or exchange of $200,000 for $200,000?
Yes.
Okay, so did the agreement call for an exchange or swap of $200,000 to be swapped out for another $200,000, or did it call for a $200,000 loan?
A $200,000 loan.
Good. So is the bank to follow the Federal Reserve Bank policies and procedures when banks grant loans?
Yes.
So what are the standard bank bookkeeping entries for granting loans according to the Federal Reserve Bank policies and procedures? And I'll hand you now the Banker Fed publication entitled Modern Money Mechanics, labeled Exhibit C.
The promissory note is recorded as a bank asset, and a new matching deposit or liability is created. Then we issue a check from the new deposit back to the borrower.
So then, is this not a swap or exchange of $200,000 for $200,000?
Well, this is the standard way we do it.
Answer the question. Is it a swap or exchange of $200,000 actual cash value for $200,000 actual cash value? If the note funded the check, must they not both have equal value?
Well, I'm sorry, I'm going to have to plead the Fifth Amendment on this.
Okay. Tell me, if the bank's deposits or liabilities increase, do the bank's assets increase by an asset that has actual cash value?
Yes.
Is there any exception?
Not that I know of.
So if the bank records a new deposit and records an asset on the bank's books having actual cash value, would the actual cash value always come from a customer of the bank or an investor or a lender to the bank?
Yes.
All right. Is it the bank policy to record the promissory note as a bank asset offset by a new liability?
Yes, it is.
Does the promissory note have actual cash value equal to the amount of the bank loan check?
Yes.
Then, does this bookkeeping entry prove that the borrower provided actual cash value to fund the bank loan check?
Well, yes, it does. The bank president told us to do it this way.
All right. How much actual cash value did the bank loan to obtain the promissory note?
Nothing.
Then how much actual cash value did the bank receive from the borrower?
$200,000.
So then, is it true you received $200,000 actual cash value from the borrower plus monthly payments, and then you foreclosed and never invested 1 cent of legal tender or other depositor's money to obtain the promissory note in the first place? Is it true that the borrower financed the whole transaction?
Yes.
Are you telling me the borrower agreed to give the bank $200,000 actual cash value for free, and that the banker returned the actual cash value back to the same person as a bank loan?
I was not there when the borrower agreed to the loan.
Do the standard Fed publications show the bank receives actual cash value from the borrower for free, and that the bank returns it back to the borrower as a bank loan?
Yes.
Okay. Do you believe the bank does this without the borrower's knowledge or written permission and authorization?
No.
To the best of your knowledge, is there written permission or authorization for the bank to transfer $200,000 of actual cash value from the borrower to the bank and for the bank to keep it for free?
No.
Does this allow the bank to use this $200,000 actual cash value to fund the $200,000 bank loan check back to the same borrower, forcing the borrower to pay the bank $200,000 plus interest?
Yes.
Then if the bank transferred $200,000 actual cash value from the borrower to the bank, in this part of the transaction, did the bank loan anything of value to the borrower?
No.
Is it the bank policy to first transfer the actual cash value from the alleged borrower to the lender for the amount of the alleged loan?
Yes, it is.
Does the bank pay IRS tax on the actual cash value transferred from the alleged borrower to the bank as income?
No, because the actual cash value transferred shows up like a loan from the borrower to the bank, or a deposit, which is the same thing, so it's not taxable.
If a loan is forgiven, is it taxable?
Yes, it is.
Is it the bank policy to not return the actual cash value that they received from the alleged borrower unless it is returned as a loan from the bank to the alleged borrower?
Yes.
You never pay taxes on the actual cash value you received from the alleged borrower and keep it as bank's property?
No. No taxes paid.
When the lender receives the actual cash value from the alleged borrower, does the bank claim that it then owns it and that it is the property of the lender without the bank loaning or risking 1 cent of legal tender or other depositor's money?
Yes.
Are you telling me the bank policy is that the bank owns the promissory note, which is the actual cash value, without loaning 1 cent of other depositor's money or legal tender, that the alleged borrower is the one who provided the funds deposited to fund the bank loan check, and that the bank gets funds from the alleged borrower for free? Is the money then returned back to the same person as a loan, which the alleged borrower repays when the bank never came up with any of its own money to obtain the promissory note? Am I hearing this right? I give you the equivalent of $200,000. You return the funds back to me, and I have to repay you $200,000 plus interest. Do you think I'm stupid?
All the banks are doing this. Congress allows this.
Does Congress allow the banks to breach written agreements, use false and misleading advertising, act without written permission, authorization, and without the alleged borrower's knowledge to transfer actual cash value from the alleged borrower to the bank and then return it back as a loan?
But the borrower got a check and the house.
Is it true the actual cash value that was used to fund the bank loan check came directly from the borrower and that the bank received the funds from the alleged borrower for free?
This is true.
Is it the bank's policy to transfer actual cash value from the alleged borrower to the bank and then keep the funds as the bank's property, which they then loan out as bank loans as if they actually owned it and loaned their own money?
Yes.
Was it the bank's intent to receive actual cash value from the borrower and return the value of the funds back to the borrower as a loan?
Yes.
Do you believe that it was the borrower's intent to fund his own bank loan check?
I was not there at the time, and I cannot know what went through the borrower's mind.
So if a lender loaned a borrower $10,000 and the borrower refused to repay the money, do you believe the lender is damaged?
If a loan is not repaid, the lender is damaged.
So is it the bank policy to take actual cash value from the borrower, use it to fund the bank loan check, and never return the actual cash value to the borrower?
The bank returns the funds.
Was the actual cash value the bank received from the alleged borrower returned as a return of the money the bank took, or was it returned as a bank loan to the borrower?
As a loan.
So how did the bank get the borrower's money for free?
That's how it works.
No more questions, Your Honor.
Good luck.